Now, as a point of departure, it is very important for the parties who allege unfair dismissal to understand what Labour Relations Act requires the parties to be before the allegement. When you allege, you must first establish that you are an employee. Now, in order for you to be an employee, you must fall within the definition of an employee, which is contained in the Labour Relations Act. Now, in terms of that definition, an employee is a person who works for another person or for a state who in turn receives remuneration or is entitled to receive remuneration. And the second part of the definition also includes any other person who assists in conducting a business of another. So if you don't fall within that definition, it doesn't necessarily mean that you cannot be an employee in terms of the Act, because the Act in itself contains a list of circumstances in terms of which a person can be presumed to be an employee, even though he doesn't fall within the definition section. Now, the presumption section is contained in Section 200A of the Labour Relations Act. That section just lists a number of scenarios in terms of which a person can be deemed or presumed to be an employee. If you do or render one of the services listed in that section, it just presumes you to be an employee, and then the onus shifts on the employer to prove otherwise. Now, once you have established that you're an employee, the second thing that you have to establish is that dismissal took place. Now, the question that arises is what constitutes a dismissal? Section 186 of the Labour Relations Act defines a dismissal as termination of an employment contract by the employer with or without notice. The employee reasonably expected the employer to renew a fixed-term contract on the same or similar terms. However, the employer failed to renew it or renewed it on less favorable terms. The employer failed to allow an employee to resume work after the employee took maternity leave as permitted by the law, collective agreement, or the contract of employment. The employee terminated the contract of employment because the employer made continued employment intolerable. The employee terminated the contract of employment after a transfer that was contemplated in terms of Section 197 and 197A of the Labour Relations Act, because the employer made circumstances less favorable than those that were provided by the old employer. Now it must be established that there are different types of dismissal. The most common one is automatically unfair dismissal. Now, when one is reading the Labour Relations Act, one must take note that the heading of the Act in itself gives a brief description of what the provisions are contained. For example, automatically unfair dismissal creates the impression that the dismissal in itself is automatically unfair. The reason that it's automatically unfair is because the provisions that are contained in Section 187(1), which deals with automatically unfair dismissal, relate to infringement of fundamental rights. For example, they include dismissal of an employee for reasons contrary to freedom of association, dismissal of an employee because the employee participated in a protected strike or intended to participate in a strike, dismissal of an employee because the employee took action against the employer or intended to take action against the employer based on reasons provided by the Act. The employer dismissed an employee because the employee got pregnant or intended to get pregnant, and all the other circumstances that are contained in the Section 187. Now, you've got to understand now, if you allege unfair dismissal, there are certain remedies that you are afforded. Remedy that's most common to vulnerable employees is that they refer the matter to CCMA or the bargaining council. Now, you've got 30 days to refer the dispute to CCMA or the bargaining council. The 30 days starts to commence on the date of dismissal or the date the employee became aware of the dismissal. Now, after you've referred the matter to CCMA or the bargaining council, the CCMA and the bargaining council will try and conciliate the matter within 30 days after the referral. And after conciliation, they will issue a certificate of whether the matter was resolved or not resolved. If the certificate provides that the matter was not resolved, then the parties can refer the matter for arbitration or to the Labour Court for adjudication. For further information on this topic, please contact Ncume at Craven State's Attorneys.